Sometimes he has one. So.
Yeah, let me see if I got one. I can't remember. If you do. Yeah, let me see. Thanks.
You put one on the officer's desk?
I did.
Thank you. Good morning, everybody.
Good morning.
Good morning.
All
Good
right,
morning, Kitty. It's Dan Waszak. I'm here about the matter we discussed yesterday.
I forgot.
That's the Sean Hoskins live exam at 10:15,
Oh, okay.
and he is present.
All right, who's next?
Good morning, Kate DeMacgrady. I'm on Charles Marshall and Shanika Brown. They're both PCC out of custody.
In the trucking chain, no problem.
Can I have your P number?
83667.
Oh, Brown and who else?
Charles Marshall.
Mark. All right, who's next?
Thank you.
Catherine O'Mara. I have Curtis Johnson.
Curtis Johnson. All right, I got you, Catherine. Who's next?
Good morning, Kitty. Jonathan Simon on ACOX. This is the one I just called you about. It's a 10:30 exam, but it's here and it's going to be a waiver.
Hey, Cox. All right, who's next?
This is Sharon Payne. Good morning. I'm here on Kenneth Green for a PCC. I do have a co-defendant representing Marquis Rankin. I don't know who that is, though.
I'm McPhail. I'm retained counsel for Mr. Rankin.
Okay.
Good morning.
Retained counsel on Rankin. I don't have an appearance for you. Did you file one?
I did. I filed it electronically through the 36th District Court website on Friday. On Monday.
Okay, it's not in the system either. What's your P number?
I apologize. Go ahead.
I need your P number. Okay, you cut up. You're gonna have to repeat it.
Sorry, 70739.
Okay, and I'm gonna need you to email me a copy.
I will do that. I also had an opportunity yesterday to speak with the attorney's office that was court appointed on Mr. Rankins, and I had advised them that I would be appearing today. Mr. Rankins had a retained my office on Sunday.
It's all broken up.
Okay, you're going in and out and you're breaking up. So just wait, ma'am. Counselor, just wait until we call the case, okay?
Okay.
Who's next? Checking in.
Attorney Andrea Fanning. I have Vince McKinney scheduled for a 10 o'clock exam. I'm just letting you know I will check back in closer to that time. I will decide what we're going to do when we return. Thank you.
In person, Ms. Fanning?
Yes?
Is that for in person?
Your Honor, if it depends on if the people are ready to proceed or not. If the people are not ready to proceed, it will probably be a waiver. So I will be appearing Zoom. Even if it's not, we will be doing it via Zoom, please. The exam or the waiver. I've discussed it with my client.
Okay, you didn't discuss it with the court.
Okay.
You said ask for it in person.
Madam Clerk? Or Mr. Clerk?
Well,
Hello?
I guess I will return at 10.
We're talking. Go ahead, Ms. Fanning.
Your Honor, how do you wish for me to handle this?
Well, are you holding the exam? No, you don't know yet.
Your Honor, no, I know what I'm going to do. If the people are not ready to proceed, I've already discussed it with my client. I know that it's a waiver. I don't have to guess about it. I know that it's a waiver. We've already discussed it.
Okay.
Good morning, Judge. I'm sorry. I'm having trouble with a new computer and my internet connection is not precisely secure. It's coming in and out today. Oh, wait.
As you see, with that being said, then you
court reporter's designation that actually is saying.
If you're not in the hearing and directly talking about your case, please put your systems on mute. Go ahead, Ms. Fanning.
Your Honor, with that being said, how do you wish for me to handle it? Because I told my client that you are an early judge, but I know that we were scheduled for 10. So I don't know if the prosecutor can tell me at this time whether or not he'll be ready to proceed. Clearly, if he's not, I will be asking for a dismissal, but my client knows what time we're scheduled for. So I will handle it whatever way the court wants me to.
I mean, well, if you're waiting for him to see if he has his witnesses, then we're gonna call the case at 10 o'clock.
Okay. Okay. I will return then, if that's okay. Thank you.
Okay, thank you.
All right, who's next checking in?
Latonya Williams.
I need attorneys checking in. If you have a case, just wait for your attorney to check in.
Yes, I'm checking in. I'm Elliot Margolis, and I'm checking in on Cortez Santino Blake.
Okay, I got you. Who's next?
Okay.
Avery, did you get Avery? Avery Bradley?
Yes, good morning, Judge. This is Avery Bradley. I'm checking in on Ian Hargraves.
Hargraves. Are you retained on it?
Yes, I am.
Okay, I don't have an appearance. Did you file one?
I haven't filed it yet, Judge, but I'll be happy to do that.
Okay, what is your P number?
33630.
Okay, can you email me your appearance?
Yes, I need your email address.
It's orqiu.ial@36districtcourt.org.
Okay, just would you repeat it just one more time?
QUID as in David, IA.ORIEL@36districtcourt.org.
Okay.
Who's next checking in, attorney wise?
Well, we got the,
Rebecca Tiapo checking in for Ian Hargraves, please.
You've been retained out, Ms. Tapple.
Thank you. Okay, thank you.
Wayne County, who do you have?
Hello, good morning. I have two ladies sitting here with me. I have Katerina Ampolfo
Okay.
and Monique Carson.
Monique Carson. Yep. All right, thank you. We're waiting on their attorneys to check in.
Okay, thank you so much.
Who's next checking in?
Madam Clerk, good morning. My name is Adam Clements. I am retaining in on Charles Marshall's case. It's a CCW.
It's a PCC today?
Yes.
Counselor, did you hear that?
Yes.
Okay,
Mr. Marshall
okay.
just informed me of that via text as well. Thank you.
Oh, okay. Mr. Clemens, I need your P number, and did you file an appearance?
Yes. But I can do it again. My P number is 77233.
Yeah, I don't have one, and it's not in the system. All right, who's next? Any other attorney need to check in?
Madam Clerk, should I email it to you? If so, if you give me your email address, I'll send it now.
Yes, please.
Okay.
Good morning, this is Tim Rather. I need to check in.
Who you on, Mr. Rather?
I have Katerina Ampofo, AMPOFO.
Tim, that's me. I retained in yesterday. Vassal Johnson here.
Oh, great. Okay, buddy. Thanks, man.
Sure.
And then my name is Ron Marsh for James Young.
For James, you said James Young?
Yes, my name is Ron Marsh, his attorney.
Are you retained, counselor?
Yes, and I entered my appearance on December the 21st, and I've received discovery. Court-appointed counsel contacted the defendant yesterday. The defendant informed the court-appointed counsel that I was retained. I'm retained, yes.
Okay, I need your P number and I need your appearance.
Ron Marsh on behalf of James Young, P26471.
You said 226?
No, 26471.
26471. Okay, for the attorneys that are retained, can you please email me a copy of your appearance?
And what is your email address?
Email is orqiu@36districtcourt.org.
I am so sorry. I didn't get that. Can you restate it just a bit louder?
ORQUID as in David, IA.ORIEL@36districtcourt.org.
All right. ORQUIDIA.ORIEL@36districtcourt.com.
.org.
Thank you. All right. Can my secretary do that this afternoon?
This morning.
I need it this morning, counselor.
All right.
Hey, Madam Clerk, Vassal Johnson here. Did you get my appearance to your email yesterday?
Yes, I have your appearance.
Okay,
Thank you.
thank you.
You said who, Judge Elder?
Yeah, Elder's at work. He walked in the court, but he's coming back on the hallway.
Ken?
He's on the motion here. Yes. Yes, did somebody call me? No? Okay. Any other attorney need to check in? What other case was Mr. Elder on? Oh, he's on, Tanya Williams. So I'm ready to call Judge. So. Oh, we don't.
Oh, it's in,
First. Yeah, Mr. Elder come in too. Mr. Basso, did you need to talk to your client in the breakout room?
Sure, please. Thank you.
That's the female in Wayne County Jail.
I'm here. I have her taking a seat right now.
See. Thank you.
You're welcome.
You want me to put this case first, Jim?
Excuse me, good morning.
Yes, good morning.
Yeah, this Mr. Mackenzie Acox.
He's on a 10:30 exam.
Oh,
Yeah, that's gonna be a waiver.
oh, that's, Simon's case.
All right, just wait till your case is called, please. Put your system on mute.
Okay.
You ready, Mr. Elder?
Yes, ma'am.
Calling case number 2062681, the people of the state of Michigan versus Delano Brown. Defendant is charged with count 1, assault with intent to murder. Count 2, weapons, firearms, discharge from vehicle. Count 3, weapons, firearms, discharge enter at a building. Count 4, weapons, felony firearm. Count 5, weapons, felony firearm. Count 6, weapons, felony firearm. Count 7, weapons, felony firearm. Count 8, weapons, firearms, possession by a felon. Count 9, weapons carrying concealed. Offender for notice, mandatory 25-year sentence. This matter is scheduled for is it a bond motion hearing?
Good morning, Your Honor. This is Preston Blair.
Good morning, Honor, to your staff, the Ray Elder, for Mr. Brown, which is standing behind me to my left. My paper is 5772.
Colonel Brown is present. Your Honor, we did submit a motion, I'm sure the court's apprised of it. Yeah. Got a witness? I do, Your Honor. All right. We have also a recording on the phone, albeit it's not super loud. I don't know if it could be amplified through the words microphone or what have you, but we'll see how we go, okay? All right. Shall I bring her in the courtroom? Yeah. Thank you. Open that door. Yeah.
Kitty. Also on Miss Williams. Okay. I'll be here.
Counts of K and IDHT. Good morning. Call up. Where our firm, truth, no truth, and nothing but truth. Ma'am, thank you, you're right. Good morning, ma'am. Your name again, record?
Monica Knight.
Okay, Miss Knight, do you know Delano Brown?
Yes.
How do you know Delano Brown?
That's my daughter's father.
Your daughter's father?
Yes.
Okay. And, you know a Mr. Eric Johnson?
Yes.
Okay. How do you?
He's my friend.
He's your friend?
Yes.
Okay. And, you're familiar, is there a case going on with Mr. Delano Brown?
Yes.
Okay. And are you part of that case?
Yes.
How-
What, Eric? Or
Well, you're a witness to the case, right?
for that one, right?
Okay, very good. Now, at some point in time, can you tell the court if you have been contacted by Mr. Delano Brown, either directly or indirectly, since May 3, 2020?
Yes. Contacted indirectly.
And how were you contacted?
He has left several messages on my mother's, house voicemail.
Okay, and, did you hear those?
Yes.
All right. And can you tell the court basically what he was indicating to you and or your mother or to whom? You strike that.
So basically to my whole family, he said that we all must die. I took his daughter away from him.
The lowest more.
Hold on, put your systems on mute if you're not in the hearing.
We all must die. Just keeps saying Pyru 984. That's the game he's claiming. It's just, we must die. We must die.
Okay, now, he said we must die. Did he name anybody?
From the mama all the way down. That's what he said. From my mother all the way down. The Knights, which is my whole entire family. We're all Knights.
Okay. Now, these phone messages came through when? Do you remember?
Yes, they came December 31st, 2020.
All right, and how did they make you feel after you heard them?
Sick, disgusting, because he's threatening my whole entire family, including me. So I don't want to have to look over my shoulder, wondering if he's coming up, trying to kill us.
Since that date of December 31st, 2020, have you seen or heard from Mr. Delano Brown?
No.
And you do have that recorded message on your phone?
I do have these recordings.
Thank you.
Man, how long have you known Mr. Brown for?
I've known him for about 8 years.
And he also knows your mother, is that correct?
Correct.
And you have a child in common, is that right?
Yes.
And when's the last time you allowed him to see his child?
That's not right.
That's okay, that's no problem. All right. You indicated
Madam
that-
Clerk?
that
We're in a hearing, please.
He left messages.
Madam Clerk?
In a hearing, Mr. McCollum, please wait.
You indicated the messages were left on a house phone, is that correct?
Yes.
Or you indicated that there's a message saying that we all must die?
Yeah.
And the house phone obviously has that these messages are dated, is that right?
Correct.
Okay, can you please play the message if you're talking about where it says we all must die? You indicated,
Well, one second. You recognize the voice on the phone?
Yes.
Whose voice is that? Right. Thank you, Judge.
nothing further on.
That was the question I wanted to ask.
Ma'am, that's a complete record of the audio, is that correct?
Yeah.
Nothing further on.
Anything further? You step down, man. Thank you.
I got it.
Anything else, Mr. Moody?
Judge, no, thank you very much.
No,
Your Honor, obviously, it's a rent, he goes, the individual on there goes on a rent, Judge. The only thing is, they're not dated, Judge.
Not what?
It's not dated, Judge. I mean, I don't, she indicates that this is on December 31st, Judge.
I have one testimony.
Okay, Your Honor, in terms of contact with the mother, leaving at the mother's phone, Judge, he indicates, oh, y'all bitch, something died, Judge. I don't know if that's more of just a rant, Your Honor, because obviously here he wants to see his daughter in there, or this is just an actual threat, Judge. Obviously, it's someone that's upset about his daughter. Your Honor, I understand the court gave an instruction for him not to have contact with the witness, Judge.
I gave an instruction with anybody. My, what I say with regards to no contact has never changed. You cannot contact, nobody else can contact. Go through telephone, text message, email, voice. I go through the whole bit. Let people know they can't do anything about this on social media. So, I mean, it is what it is.
Yeah, I understand, but Judge, look, I mean, it's contact, obviously, with the mother, Judge, but is this more of his emotions getting the best of his daughter?
I don't care.
Right.
Okay. At this point, it doesn't matter.
If you make progress in a day, we come back earlier. Certainly, Judge. Mr. Collins.
All right. Anything else? I'm not cutting you off.
No, yeah.
Nothing further from the people, Judge. Just
All right.
it was hard to hear it, but there were some things that were mentioned by the witness. Nothing near content.
That definitely wasn't hard to hear from me. It was clear. He made several threats.
Right.
The bonds increased to 100,000 cash. I'm gonna move up his preliminary exam date. If you make that bond, it's going to be with a GPS tether, he'll be on house arrest.
Yeah, will the court consider 10% bond?
Nope. Wait, I gotta give him a date.
And we're going to be doing flavor.
Please.
Ms. Clerk?
Hold on, please. We're in a hearing. That's for February 12th at 10:45.
Jen, I'm sorry, what was it?
10:45. Mr. Margolis, what is it, please?
No, I'm already on that Santino matter, Cortez Santino. All we're gonna do, I need to get discovery, so all I'm gonna do is ask for an adjourned date and waive his presence if he's not on.
All right, well, we got checked in.
Okay. I'm waiting to argue a motion in front of Judge Knapp as well, so anything you can do.
All right.
Thank you.
Ready on Williams?
Ready.
Calling case number 2062681, the people of the state of Michigan versus Latanya Williams. The defendant is charged with count 1, weapons, taser, possession, or sale of. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. People.
Good morning, I'm DeRay Elder, on behalf of Latanya Williams. And I'm not sure if Ms. Williams is with us via Zoom. I did try calling the number, the voice principal. She is not.
Williams, state your name for the record, please.
Latonya Williams.
Heather, I did receive discovery on the 25th. I do have complete discovery, Your Honor. I'm asking the court to send this for an examination, please. The court doesn't send it.
How many witnesses?
There are 2 witnesses. I'm able to do 1.
Is it February 3rd? 10:45?
I'm sorry, Judge, what's the date?
February 3rd at 10:45.
I'm sorry, Judge.
February 3rd, 10:45.
2, 3,
Yep.
10:45. Thank you.
Yeah, can we do a little later in that day? Maybe an hour?
I got things scheduled. Hold on. We'll do February 4th at 10:30. Good day. Can I ask Ms. Williams one question? Ms. Williams, does your number end with 9172?
No. It's 248-470-8909.
Thank you. Thank you, Judge. Have a good day. Good to see you again. You take care. All right.
Ready on Hoskins? Daniel Wiseman.
Is I'm done?
Yes, you're done. You go. You can sign off. Talk to you later. Thanks.
Huh?
Yes, sir.
You can log off, Ms. Williams. Is Daniel on, Judge? Ready on Hoskins?
Oh, last name?
Yeah.
Yes, ready on ACOX.
Okay. Calling case number 2059497, the people of the state of Michigan versus Deshaun Hoskins. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for an examination.
Good morning, Jonathan Simon, P35596, on behalf of Mr.
No, it's not your case.
Oh.
It's Hoskins.
Sorry, I thought,
That's all right. Mr. Wasnick is not on. We can go to the next one. He's in the background, so he must be on. He's not responsible.
Ready on Brown, Shakia Brown?
Yes.
Calling case number 2062678, the people of the state of Michigan versus Shakia Brown. Defendant is charged with count 1, license documents, plates, forgery. Count 2, identity theft. Count 3, operating license suspended, revoked, denied. Count 4, operate unregistered vehicle. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. May it please this court, Reginald Andrew, P number 80354, appearing on behalf of the people.
And good morning, Your Honor. Neighborhood Defender Service by Kate DeMott Grady, P 83667, on behalf of Ms. Shanikia Brown, who's joining us via Zoom. Ms. Brown, can you please unmute yourself and state your name for the record?
Shanika Brown.
Thank you. Your Honor, I have not received any discovery at this time, so I'm renewing my request for discovery and asking for an in-person preliminary hearing. Just for the court to be aware, I'm in a mandatory training next week, so I'm asking for an exam date the week of February 8th through 12th to accommodate my schedule if the court would allow. Thank you.
Ms. Brown? Ms. Brown?
Yes.
I don't do t-shirts. I don't do anything in my courtroom. You understand?
I'm sorry, I can't hear you.
I don't do t-shirts or sweats or head wraps or anything like that in my courtroom.
Yeah, my lawyer told me, but I'm at work right now, so I haven't gotten my car to Zoom.
Brown, I don't care.
Okay.
Where you at? You're in my courtroom now.
Okay.
So when you're in my courtroom, you dress appropriate. If you can't, then I'll dress you.
Okay,
I'll send you to jail and and they'll dress you.
Oh,
do I have to do that? Do I have to do that, ma'am?
No.
All right.
more.
Margaret, are you available on the 8th,
Yes, Your Honor.
10 o'clock?
Thank you. Ms. Brown, you can sign off now.
Mr. Brown. Okay. Oh, yeah, okay.
Ready on Hoskins?
I saw that. He was on, he was in the background, so he must be on somebody else.
Ready on Johnson, Curtis Johnson?
Ready.
Calling case number 2059418, the people of the state of Michigan versus Curtis Johnson. Defendant is charged with count 1, weapons carrying concealed, count 2, controlled substance, possession, cocaine, heroin, or another narcotic, less than 25 grams. Count 3, weapons, felony, firearm. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. This is Prosecutor Ronald.
And good morning, Your Honor. Catherine O'Mara on behalf of Mr. Johnson.
Mr. Johnson on?
I believe he is on.
Yes. Mr. Johnson, state your name for the record, please.
Curtis Johnson.
Mr. Johnson, you heard what I said about t-shirts? I don't do
No.
t-shirts, I don't do sweats in my courtroom, sir. You dress for court. You can't dress for court, I dress you. Send you Wayne County Jail, let them put you in green. All right?
Yes.
Shirt with a collar, pair of pants, that's all I ask for. Okay?
All right. Yes.
All right, thank you. All right, Mr. Mayor, what are we doing?
Your Honor, I've been trying to submit a request to the gun committee on this prior to setting it for an exam, but we haven't been able to complete that. I don't know if the court wants to just set it for an exam or reset the PCC so we can get that in.
All right, I'll set it for exam.
Okay.
2 witnesses, Judge.
February 22nd at 10:15.
Your Honor, I have another exam that morning in Allen Park.
February 19th at 10:30.
Oh, I'm also otherwise engaged on February 19th in 3 different other courts.
February 18th at 11:30.
I think that would be, I have an exam at noon in Judge King, so you think I'd be ready for that by then?
How many witnesses?
Oh, I'm sorry, Judge. I too.
We'll be ready. Not gonna take long to do.
Yeah, then the 18th at 11:30 is fine. Thank you.
All right. You get an answer from the gun board before then, just contact the court.
Thank you, Your Honor.
All right, thank you. File continued.
Mr. Wasnick, is he still in the background too?
Yep.
Ready on Acox?
Yes.
Calling case number 2059501, the people of the state of Michigan versus Mackenzie Acox. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
Good morning, Jonathan Simon, on behalf of Mr. Acox. Mr. Acox, please unmute your microphone and introduce yourself to Judge Giles.
Still on mute. You gotta unmute yourself, sir.
Can you hear me now?
Yes, we can, please.
I said, good morning. My name is Mackenzie Acox.
All right. All right, Mr. Simon.
Your Honor, this matter is set for 10:30 in-person preliminary examination. After consultation with Mr. Acox, we have asked the court to hear us by Zoom for the purpose of conducting a waiver of that examination.
All right. Mr. Acox, you understand that you have a statutory right to preliminary exam where the state must show by probable cause a crime was committed and probable cause you had something to do with that. You understand that?
Yes, Your Honor.
Anybody promise you anything or threaten you in any way to get you to waive your right to a preliminary exam?
No, Your Honor.
You're waiving your right freely and voluntarily after having opportunity to talk to your attorney about it.
Yes, Your Honor.
Do you have any objection to the court signing your name to the waiver form and initialing off?
No, I do not.
Mr. Simon, do you have any objection to the court signing your name to the waiver form and initialing off?
No, Your Honor.
And people have any objection?
No, thank you.
All right, court will find that you freely and voluntarily waive your right to preliminary exam that is bound over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be February 10th, 2021 at 9:00 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Still no Daniel.
Am I all set?
Yes, you are, sir. You can sign off.
Ready on Rankin and Green? Calling case number 2062574, the people of the state of Michigan versus Marquise Rankin. Defendant number 1 is charged with count 1, weapons carrying concealed. The people of the state of Michigan versus Kenneth Green. Defendant number 2 is charged with count 2, weapons carrying concealed. These matters are scheduled for probable cause conferences.
Good morning, Your Honor. Voting for the people.
Good morning, Your Honor. Christina McPhail Stockdale, that's P70739, on behalf of the defendant, Mr. Keith Rankin. I'm sorry, I hope I didn't cut out.
No, we got you. I got it.
Okay. Good morning, Your Honor. Attorney Sharon Payne, P38749, representing Mr. Kenneth Green, who is also present via Zoom. Mr. Green, would you please unmute yourself and identify yourself for the court?
Good morning. My name is Kenneth Green.
Mr. Green, you have video?
Yes, I do.
All right, thank you.
Likewise, Your Honor, Mr. Rankin is also present via Zoom.
Mr. Rankin, state your name, please.
Marquise Rankin.
All right, thank you, sir. All right, we set up for exam.
Your Honor, on behalf of Mr. Green, this is the first time this case has been up. I just got discovery yesterday. I need to discuss it with my client. I do believe that I want to write a gun board letter. So I am requesting, with the court's permission, to adjourn the probable cause conference or to set a preliminary exam about a month out.
Yeah, I don't adjourn probable cause hearing, counsel. Yeah,
Okay,
I'm trying to move the docket now, so I'm not putting them out that far.
okay.
If I can do. Two witnesses? Yes.
Your Honor, may I, if it pleases the court?
Yes, ma'am.
On behalf of Mr. Rankin, Your Honor, likewise, I was just recently retained. I understand that there was court-appointed counsel. I am not in receipt of the discovery. Court-appointed counsel may have. I did speak with them yesterday, and I don't think that that attorney had the discovery yet. So, like our co-sister counsel, I too would like to schedule a time to be able to either adjourn to another pretrial, if it pleases the court, or to just merely set it for exam to give us an opportunity to review that discovery and make decisions as to how we want to proceed.
All right, I'm gonna set it for exam, counsel.
Thank you, Your Honor.
Ms. McPhail, discovery was sent to appointed counsel at NDS on the 25th of January. They should have had it, but I will resend it to you. I've got your P number down now.
Thank you. I appreciate that.
All right, well, I'll give you a little time if you want to go to the gun board. March 2nd at 11 o'clock.
March 2nd at 11 o'clock works fine for me, Your Honor.
Likewise, Your Honor. Thank you.
Thank you very much.
You go to the gun board and they accept your clients. Please let the court know so we can move it up.
Will do, Your Honor.
All right,
Thank you, Your Honor.
thank you.
Bye.
Bye now.
Bye. Thank you.
Daniel, are you on?
No, he's not. Oh, no, he's not even on. Nope.
Ready on Cortez Blake? Calling case number 2062676. The people of the state of Michigan versus Cortez Blake. Defendant is charged with count 1, weapons carrying concealed. Count 2, police officer assaulting, resisting, obstructing. Count 3, weapons felony firearm. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. This is Prosecutor Blair.
Oh, he's not on either.
Nope.
All right, I'll recall it. Ready on Hargraves? This retained counsel.
Is that Mrs. Rebecca Tempio?
No, she got retained out.
Oh, she did?
I think it's, I forgot his name, the one with
Avery
glasses.
Bradley.
Oh, Mr. Bradley.
Yeah.
Bradley?
Calling case number 2062592, the people of the state of Michigan versus
It's Ian.
Ian Hargraves. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. This is the prosecutor, Glenn Williams, People.
Good morning, Your Honor. May it please the court, Avery Bradley, retained counsel P33630 on behalf of Mr. Hargraves. Mr. Hargraves, are you present?
Yes, good morning, Your Honor. My name is Ian Hargraves.
All right. What's your pleasure, Mr. Bradley?
Your Honor, like the other counsel this morning, I'm going to be submitting a letter to the gun board, and I'd ask that this matter be adjourned out in time for me to get a letter in and get a response. I'm also requesting discovery in this matter. I have not received discovery. I'm just retaining in.
Available March 1st at 10 o'clock.
That's a good date, Your Honor. Thank you very much.
Thank you.
To the prosecutor, can I give you my P number or my email?
Yeah, is your P number 33630?
Correct.
Okay, good, thanks. It went to the other counsel, so that's why you don't have it.
Okay.
Oh, I'm sorry, Judge. It's one. That's 3/1/21 at 10 a.m. Is that correct? Yeah. Okay.
Yep. Mr. Margolis is back.
Yes, I am.
Calling case number 2062676, the people of the state of Michigan versus Cortez Blake. Defendant is charged with count 1, weapons carrying concealed; count 2, police officer assaulting, resisting, obstructing; count 3, weapons felony firearms. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. This is Prosecutor Glenn Williams, the people.
Elliot Margolis on behalf of Cortez Blake, Your Honor, P28078. And I would ask the court to waive his presence if he's not on Zoom.
Mr. Blake, are you on? All right, court will waive his appearance for the purpose of this hearing.
Your Honor, I'm requesting discovery. I haven't obtained any discovery, and I don't have a contact phone number for the defendant. So if we could adjourn this matter for me to get discovery, and if the court can look at the file to see if there's a phone number for him, I would appreciate it.
Mr. Margolis, discovery was sent on Monday, January 25th to your email. Our records indicate it was successfully sent to your system. So you may want to check your email or spam. It is there.
Okay, I didn't see on January 25th. That was just yesterday, Yeah, I haven't seen that, but I need to review the discovery anyway, and I need to get a contact number. And I do see I have one evidence.com message that I haven't opened up yet from the 25th, so that must be you.
His contact information most likely would be in there too.
The court doesn't have any contact information.
You have no phone number on the order of appointment or anything, Judge? Or
appointment. His address is in the discovery, though. I don't have a phone number here, from what I can tell real quick.
Okay. I'll look at the discovery for an address on him, and I'll need to send him a letter.
Oh, you know what? There is a phone number here. I don't know whether I want to give it on live YouTube or what.
Can you put it in the chat?
I'm in the courtroom.
Oh. Can you send it to me?
Well, it's in discovery.
Huh?
It is in the discovery.
His phone number is?
Yes, sir.
Oh, okay. Okay, that's fine. That's fine then, Blair. Can we just get another date?
I'll give you a date for an exam.
That's fine.
Okay. Thank you. All right. Yes.
I would ask for an in-person.
Yeah. February 26th at 10:30.
February 26th. At 10:30?
Yes.
That's good, Judge.
Oh, I'm sorry. I have one.
That's Mr. Neil Brooks. His attorney isn't here. They haven't arrived. Take this so far.
May we leave, Judge? May I leave?
Yes, you may.
Thank you.
What about a David? Ara, David?
They haven't came yet.
All right, call that. David.
Calling case number 2059503, the people of the state of Michigan versus Jakaya Davis. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for an examination. Defendant has failed to appear.
Morning, Your Honor.
Hey, good morning, Your Honor. May it please this honorable court, Sophia Curry, P 72103, appearing on behalf of Jakaya Davis. And Your Honor, Ms. Davis is in the waiting room and her name is identified properly. Jakaya Davis.
Your Honor. Jakaya Davis for the record.
All right, we ready to proceed? People are ready, Judge.
Your Honor, I actually contacted Mr. Moody yesterday to let him know that this would be a waiver of the exam. And I did have the opportunity to discuss with my client her right to have a preliminary examination. I discussed the standard at the preliminary examination. She also understands that once she waives her right to an examination, she cannot come back at a later date and ask the court to set one. Is that correct, Ms. Davis?
Yes, ma'am. Yes, Your Honor, that is correct. I understand.
Thank you, Ms. Curry. What is your PIN number?
72103.
Thank you.
All right, Ms. Davis, you understand that you have a statutory right to a preliminary exam when the state must show by probable cause the crime was committed and probable cause you had something to do with committing that crime. You understand that, ma'am?
Yes, Your Honor, I understand.
Anybody promise you anything or threaten you in any way to get you to waive your right to preliminary exam?
No, sir, they did not.
You waive your right freely and voluntarily after having opportunity to talk to your attorney about it.
Yes, sir, that is correct.
Do you have any objection to the court signing your name to the waiver form and initialing off?
No, Your Honor, I do not have any objections.
Ms. Curry, do you have any objection to the court signing your name to the waiver form and initialing off?
No, Your Honor.
All right, court will find that you freely and voluntarily waive your right to preliminary exam at a bond over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be February 10th at 9 o'clock.
Yes, sir.
Thank
you.
Is this, sorry, sir, is this in person or on Zoom?
I'll call you, Ms. Davis.
Okay.
Okay.
Thank you, Your Honor.
You're welcome.
Ready on Hoskins? Still not on.
Cool.
Daniel.
Nope.
Ready on Marshall? Charles Marshall?
Yes, I'm ready on Marshall.
Calling case number 2062597, the people of the state of Michigan versus Charles Marshall. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. This is Carson.
May it please the court, Judge. My name is Adam Clements, P number 7723, appearing on behalf of the defendant Charles Marshall. For this proceeding, I'm asking that the court allow me to waive his presence.
Waive his appearance for the purpose of this hearing.
All right, people versus Giles.
What's your pleasure, counsel?
Sorry about that, Judge.
All right.
I'm asking for an in-person exam.
Okay. How many witnesses?
Judge, this one I have two, I can maybe do with one.
Clemens, is this an exam or is this a gun board case or what?
Can the court hear me?
I couldn't hear you now.
Okay.
I hear you now.
Okay, I'm good. I'm sorry about that. This Bluetooth was throwing off the audio. My apologies.
All right, is this gonna be an exam or a gun board case or what, do you know?
May I inquire as to who the prosecutor is on this case?
Moody. Right now it's Mr. Moody.
Okay, I have a video from the restaurant of the incident. I'm asking that I be able to send you that, Judge, and we could come back for maybe a review date. I'm hoping that this case will be dismissed.
Okay, then I'm sending it for exam.
I understand. I'm gonna work in between the dates though, Judge.
Okay. How many witnesses?
Judge, I have two, I'm able to do one.
Keep your driver's license, proof of insurance and registration in your purse.
Hold that system on mute, please. Can we do this on February 22nd at 10:45?
If we have to do it, Judge, yes, that'll work. I'll make it work.
What was it again?
February 22nd at 10:45.
Mr. Moody, I'm gonna email you some discovery and ask you to take a look at it when you have an opportunity to.
That's fine. You did not get any discovery then, did you?
I have the paper discovery, which I'm happy to have now, but I just need body cam if they have it, but I'm gonna send you video from the restaurant.
Okay, we do have digital discovery. What's the nvs.org?
MVS.org, I'm not familiar with that.
I didn't know you were on the case until now.
Oh, I'm A Clements at perkinslawgroup.net. I can put it in the chat to you if you would like.
I'm not in the court. I'm in the courtroom. I'm not online. So 77233 is your P number?
Yes.
Okay.
You ready?
You ready?
Yes.
Ready on hospital.
I got so much time.
Okay.
Have a good day, Judge.
All right, you too. Thank you.
Ready on hospital.
Yes, please.
Calling case number 2059497, the people of the state of Michigan versus Deshaun Hoskins. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for probable cause.
Good morning, Your Honor. This is Prosecutor Byron.
Joseph Dillard, 37225.
Oh, no, that's Hoskins.
That's your case.
Good morning, Your Honor. I'm Daniel Wasak, P35225 with Deshaun Hoskins.
Pleasure, counsel.
Good morning, Judge. I've had some discussion with Mr. Blair Moody, Judge. The police report in this case indicated that they had confiscated the gun registration.
Are we holding the exam?
Judge, I contacted the court on Monday and again on Tuesday to see if this matter could be adjourned because the gun board unexpectedly asked my client to present the registration that the police had already confiscated. When I talked to Mr. Heafy
Mr. Walzak, I'm not adjourning the case. Either we're holding the exam or we're not holding the exam.
Judge, I spoke to Mr. Heafy and he advised
I
that
don't
the
care.
case would have to stay in.
This is my case. Mr. Walzak, it's my case. It's my courtroom. It's my hearing. I determine whether or not it goes or it doesn't go. I am not adjourning.
Judge, you needn't yell at me, Judge. I was just trying to advise you
I
of
don't
the
need to
information.
talk over me, but I'm telling you, I'm not adjourning it.
I understand that, Judge. I was just trying to tell you the information that I was given so that you understood my position. At this time, given the court's posture, we would waive the examination if the court would permit it.
Any objection? No, thank you. Mr. Hopkins, state your name, please.
Deshaun Hoskins.
Hoskins, you understand you have a statutory right to a preliminary exam where the state must show by probable cause the crime was committed and probable cause you had something to do with committing that crime. You understand that, sir?
Yes, Your Honor.
Anybody promise you anything or threaten you in any way to get you to waive your right to preliminary exam?
No, Your Honor.
You waive your right freely and voluntarily after having an opportunity to talk to your attorney about it.
Yes.
You have any objection to the court signing your name to the waiver form and initialing off?
Yes.
No, Mr. Hoskins, he asked if you object to his signing your name to approve the waiver. Do you object to him signing
Yes.
your name or do you give him permission?
No. Okay.
Are you giving him permission?
I can hear. Yeah, I can hear.
Okay, I'm not sure what you're saying.
I agree to you signing my name to the waiver.
All right, Mr. Walzak, you have any objections to the court signing your name to the waiver form?
No objection, Judge.
All right, court will find that you freely and voluntarily waive your right to preliminary exam that is bound over the Wayne County Circuit Court Criminal Division. Arraignment on the information to be February 10th, 2021 at 9:00 p.m.
So noted.
Thank you.
Ready on Neil Brooks?
Ready on it. You got two addresses.
Yeah, are you on both of those, Mayor?
Yes.
You got both cases?
Yeah, I have, the, home invasion case.
You said you had a home invasion case?
Sally Irwin on the other one?
That's my record. Yeah.
Call a home invasion case. You trying to talk Sally? Well, just don't even worry about it.
I'm sorry.
We'll remove it, give another date. We'll get another attorney for it.
Oh, for the other case?
Is it scheduled for a preliminary exam, Yanni?
Yes.
Yeah.
9:30.
Calling case number 20-57062, the people of the state of Michigan versus Johnny Lee Neil Brooks. Defendant is charged with count 1, home invasion, first degree. This matter is scheduled for examination.
Morning, Your Honor. Prosecutor Wettley.
Joseph Dillard, P 37225, on behalf of Mr. Johnny Lee Neal Brooks, state your name for the record.
Johnny Lee Neal Brooks.
Your Honor, we're ready to proceed with the event.
People are ready to proceed, Judge. We'd ask a use for order of sequestration. In this matter, with the exception of the OIC, who is present, and it is Carmelo, sorry. And I'll take charge of the hearing with that.
Your Honor, no objection to the officers being standing in the courtroom. I would ask that if you testify and there might be compromise.
There you go. All right, you know, witnesses testifying today at trial, any future time will be the courtroom or be denied their future testimony. Your acceptance should also charge. Thank you.
Your Honor, as a matter of protocol, is my client going to be sitting up here or is he sitting in that back row?
He's in the first row. The first row.
I mean, if he has a question, would the court allow him to stand up to get my attention?
Sure.
Okay. Thank you.
Step up here, please. Where our firm. Right, close the door right here, you get a seat, sir. Smith, you're gonna be asked a series of questions. First by the prosecutor, then the defense attorney will probably ask you some questions, and I may or may not ask you questions, all right? You have to answer all your questions out loud verbally, using words. Can't just say, okay, I'm asking yes, no, excuse me. Whatever the answer is, okay? Also, when you ask a question, please just answer that question and stop. Okay, if it's a yes or no, just say yes or no, stop. If they need additional information, those are back in the question, all right? So I have a tendency, when we're talking about an event that has occurred with us involved, especially if that event is traumatic, we tend to ramble. Right, let's say this happened, and this happened, and this happened, and this happened, we'll go on like that, all right? If you do that, I'm gonna miss something. Okay. All right, and if I miss something, I might not make the right decision, okay? I know very little about this case. Everything I know about this case is the name and we charged with. Now I know your name, all right? I got all my information for what happens in court, one question, one answer at a time, that way I can understand, okay? All right, and last but not least, because of the mask and barriers, need you please keep your voice up, so everybody can hear you. You can talk directly into that microphone right there, and that will help amplify your voice. Okay, great. Thank you. May I proceed?
Thank you. Good morning, sir. Your name again for the record? David Smith. Okay. Mr. Smith, I want to take you back to the date of May 10th, 2020, the location of 10082 Violet Lawn Street. Are you familiar with that address?
Yes, sir.
And that address, how are you familiar with it?
I live here.
Okay. And on that date, did you live there?
Yes.
All right. And who lived there with you at the time?
At the time, my mother, my father, my sister, my nephew, and my grandmother.
Okay, all right. Is this in the city of Detroit County of Wayne?
Yes.
All right. On that date and time, at about, sometime in the, on that date, around in the afternoon, about 2:45, 3 o'clock or so, that something happened at where you were in the court here today? Okay. Could you tell the court essentially, what happened at that time? You were home?
Yes, I was at home. Essentially what happened was I was playing the game and I heard a knock on the door.
Okay.
It wasn't a regular, like, knock, it was a hard bang.
Okay.
So it kind of startled me. So I went downstairs, checked, and seen it was the defendant. And
Who's that?
Johnny Brooks.
Okay. You see in the courtroom today?
Yes, sir.
Can you tell us where he was in the courtroom and what he was wearing?
White shirt over barrier.
Okay, behind the barrier?
Yes.
Do you know what row? First row? For the record, identify Mr. Johnny.
Record's phone cut.
Excuse me, I apologize. Have you known Mr. Brooks for a while? How long?
Approximately, I'll say about 10 years.
How do you know him for 10 years?
He was close family, a close family friend, and he used to date my sister.
Okay. So now you're here, as you indicated, you're the you see Mr. Johnny Brooks outside?
Yes.
All right. Is he alone?
Yes, he was alone.
Okay. So did you go to the door?
Yes.
All right, what happened then?
I answered the door, and he was standing there, and he said he wanted to talk to my sister. After I asked him what happened, what did he want?
Okay, hang on a sec. Now, you answered the door. How did you answer the door?
I just opened the door, like.
Wide open, halfway, or what?
It was cracked.
Cracked?
Yeah, like I peeked through.
Okay. And you spoke to him through that cracked door?
Yes.
All right. And what was the conversation?
I asked him what he wanted from my sister. He said he wanted to talk to her. I told him that she didn't want to talk to him.
Okay, anything else you say to him?
No.
At that time? Okay. All right, so what happened?
After that, our screen door was, it was like a little messed up, but it was open. So he opened the door and tried to like barge his way into the house, and I stopped him. I was standing there, I stopped him. And
okay, hang on. Now, you tried to barge in. Did you invite him in?
No.
All right. Anybody else invite him in?
No.
When he barged in, did he say anything?
I don't recall.
Okay. Now, you indicated he barged in.
They tried.
I'm sorry?
Testimony if he tried to barge.
Okay, tried to barge in. How, did he get in the house at all?
After me and him had an altercation, we kind of like swooped into the house.
I'm sorry, he did what in the house?
Well, after me and him, he tried to like barge his way in and touch me. Like he tried to like push me into the door to get in, and I stopped him. So when I stopped him, me and him got into a physical altercation.
Where?
At the threshold of the front door.
Okay, did he cross the threshold, if you know?
Yes.
Okay. And did you say anything to him when this was going on?
I don't recall. Only thing I recall saying was she don't want to talk to you and can't be here right now.
Okay. Now, you gestured to the court. What did he do physically to you?
Like he just grabbed me and tried to push me out the way.
Okay. Where was he in relation to the threshold when that happened?
He was like trying to step his way into the door.
Did he get in or not at that time?
I was standing right there, so it was like I was standing right there, so I didn't allow him to get in, but like he was trying to force his way in.
Okay. And did he get any point, did he come in through?
Yes, after he had physically tried to swing on me and kick me.
Okay. All right. So now is he in the house at this time?
After we didn't already start fighting, yes.
Okay. What happens when he's in the house?
We were fighting.
Okay. For how long?
I'm not sure.
Okay. What happens then? fighting? Did they eventually stop?
Yes, it eventually stopped. She eventually escaped, get out the house before the police arrived. But I guess the police caught him while he was trying to escape from the house, driving away.
Okay, you indicated you escaped. Was anybody else there helping you? Or?
I mean, my father and my sister was there, but they didn't really get into the physical altercation with me. It was just me and her.
Okay. Where were your father and sister in relation to where you were?
I was like, the way our house built, it's like our living room and our dining room is like close together. So I was in the dining room and my family, my father and my sister was in the living room.
Okay. What's the approximate location from them to the front door?
Probably around like 4 feet, not far.
All right, and he left the home eventually?
Yes.
All right. And when he left the home, did you see where he went?
No, I was still in the house.
Okay. And you indicated the police were called?
Yes.
You know who did call them?
No.
Okay. Did they arrive at your house?
Yes.
Okay. And how soon did they arrive at your house after this altercation took place and he left?
I'm not sure.
Not sure? Okay. All right. Thank you. Nothing further this time. Done? Carl?
Yeah. Hey, Mr. Smith, my name is Joseph Dillard. With respect to this particular day, did your father have a gun? Yes or no? Did your father hit Mr. Neil Brooks? Yes or no?
No.
Did your sister touch
No.
Mr. Neil Brooks?
No.
Now, Mr. Brooks has a child with your sister, correct?
Correct.
And he used to stay at that house, didn't he?
No.
Did he stay overnight at any time?
Overnight?
Now, with respect to that particular day, were any shots fired, gunshots?
No.
Now, you indicated that you were at the door. You came from the dining room. How long did this struggle last?
Can you repeat the question, please?
How long did the struggle last?
Between me and Ronnie? I'm not sure. I couldn't really put a time on it because it happened so fast. I told you, it was middle of the night, I was playing a game with some friends.
Did you strike?
In defense, yes.
Pardon?
In defense.
And where did you strike?
Not sure, it just happened. And he swung on me, and after that, we just started fighting.
Did you strike him in the stomach?
No.
In the face?
Yes. It was more like casual fight.
You say, what's a casual fight?
A fist fight. A fist fight.
Now, when he came to the door, you indicated he asked for a sister, correct?
Yes.
Did you go get your sister?
She was right there in the living room.
Did you call your sister?
She was right there in the living room. She heard everything.
Did you call your sister?
She was right there in the living room. She heard everything.
Yes or no?
Yes.
So you called your sister?
No. She was right there in the other room. She heard everything.
And where was your father?
He was upstairs, but he heard the altercation going on, so he came downstairs to see what was going on.
And so what was your father's involvement? What did your father do with Mr. Neil Brooks?
He didn't do anything.
Did he try to hold him?
No.
So if he says he did anything to hold him or anything like that, that would be a lie, correct?
I would object.
I withdraw my question.
Yeah. Thank you.
When was the last time that Mr. Neil Brooks was at your house? Do you know?
Relevant.
Thank you. One moment. Yeah, and no further questions at this time.
Anything further?
Just one. Do you know if anybody in your house invited Johnny in at that date?
Not at all.
Anything further?
Nothing further, Your Honor.
All right, you can step down. Thank you.
Come on this way. Judge, we have no further witnesses this time.
No witnesses at this time.
Motion.
I do, Judge. People do, we would ask for the bind over as count 103, of course, with testimony that this gentleman did go to that location, filed at Long Street, uninvited, pushed his way in, assaulted Mr. Xavier Smith while he was present illegally in that home at the time. Nothing further to say.
Question of fact, Your Honor.
Question. Warrant to impact the current city of Detroit, probable cause of this charges presented. They'll be bound over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be February 10th at 9 o'clock.
Thank you, Your Honor. Before I leave, Your Honor, you had indicated there was another case.
Yes, I think we're calling about that we can decide.
Okay, but I'm not on that case.
You're not on the case yet. I'm seeing if I can get you assigned to it, so we'll give you another day for example. Okay?
Thank you, Your Honor.
Since you're on this one, I mean,
Might as well.
yeah.
I have extra ones, so.
shouldn't change up on me.
Nope, we just, no appointments to do it.
Yeah, me on hold all that time.
Then I'm appointing to this other case.
Thank you.
Which is malicious destruction of property case. And I'll give you a new date. February 19th at 11 o'clock.
Excuse me, let me check my schedule.
Okay.
Unavailable that day, the whole day I'm occupied. 23.
Oh.
That following week, Yana, that Tuesday, Thursday, Friday, that's the 23, 25, and the 26.
Okay, February 23rd at 11 o'clock.
Okay.
What day was it? February 23rd. Tuesday. Can you call that?
Oh, you want me to call it?
Yeah.
Yeah.
It was 11, Judge? Yeah.
Okay. Calling case number 2058490, the people of the state of Michigan versus Johnny Neal Brooks. Defendant is charged with count 1, malicious destruction of personal property, $1,000 or more, but less than $20,000. This matter is scheduled for examination.
Good morning, Your Honor. The people we are considering to proceed this morning.
For the record, Your Honor, Joseph Gordon, 37225, on behalf of Mr. Neal Brooks. Mr. Brooks, state your name for the record. Neal Brooks.
Right, well, Mr. Brooks was represented by another attorney. She has not failed to appear. So, Mr. Miller, as long as you're willing to accept it, we're gonna assign this case to you.
Yes, Your Honor.
All right, and we're gonna reschedule the exam for February 23rd at 11 o'clock.
Thank you, Your Honor.
All right, thank you.
And Your Honor, I'm requesting discovery.
Mr. Miller, make sure you get it.
In addition, Your Honor, with respect to the prior case, I'm still waiting for a 911 tape, which has not been provided to me yet.
Everything we have was presented. I don't have word at all of that money that exists.
Thank you, Your Honor. Free to go.
Thank you, sir.
Thank you.
Mr. Dillard.
Yes.
Then I'm gonna give you a copy.
Okay, thank you.
Judge, can I, right back, I'm gonna give this subpoena that witness.
Oh, no, she called me back.
Oh.
Yeah, you talking about, the appointments?
Yeah.
She ended up calling me back. Yeah, she said it was fine. So at 10 o'clock.
Yeah, baby.
Do we have a prosecutor on, Ample? Hold on.
It might be Mr. Moody.
No, it's not his.
Uh-huh.
It's not his. He told me it's not his.
Oh.
It wasn't hanging on the snow blower at all? You looked around the snow blower?
Good morning, Judge. This is Robin McCoy. I'm here on Victor Moore.
Oh, yeah. I already have you checked in, Ms. McCoy.
Okay, I just want to make sure you guys know. It's, yeah, okay.
Here you go. You want to check copy?
Thank you very much. Have a great day. Good to see you.
Thank you. Thank you.
All right, have a good one.
All right. Oh, I still don't have a prosecutor on this case. All right, so we ready? Oh, I need a
Moody
prosecutor.
comes back in and we'll see if he can.
Have a great day, court.
He told me who it was, somebody Smith.
What's that for TCC? You have to do a date and they're stuck with it. Can't come on the court online. Stuff what he's doing at 10 o'clock. Who's the attorney?
Mr. Vassal.
Yes, ma'am.
No, we're trying to see who the prosecutor is on your case.
Okay. Miss Fanning can stand in for him.
That's Kenny.
I'm ready on my case if you guys are ready.
Yeah, we're just waiting for Mr. Moody to come back in.
Thank
Mr. McKinney on Zoom?
Yep.
Okay.
Thanks, Judge. I'm all set.
Ready, I'm McKinney?
Yes.
Calling case
Yes.
number 2059495. The people of the state of Michigan versus Vincent McKinney. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
Good morning, Your Honors.
Good morning, Your Honor. If it pleases the court, Attorney Andrea Fanning, P42853, appearing with my client, Mr. Vincent McKinney. Mr. McKinney, can you please identify yourself for the record?
That is me,
State your name.
Vincent McKinney.
Thank you.
Thank you. Your Honor, today is the date and time scheduled for exam. Mr. Moody, are you prepared to proceed?
We have an officer in charge here. Sorry, Officer Hutchins, yes. And if I may have her speak to our officer, is McNeil here? Yes. He is, okay, yes, we are.
Your Honor, with that being said, I've had an opportunity to discuss this matter with my client. He's prepared to waive his right to a preliminary exam. I have advised him of the purpose of the preliminary exam, mainly that the people would have to prove probable cause that this crime was committed by him in this jurisdiction. And he is prepared to waive, understanding will be bound over to circuit court for further proceedings.
You have any objection?
Those.
All right, Mr. McKinney, you understand that you have a statutory right to a preliminary exam where the state must show by probable cause the crime was committed and probable cause you had something to do with committing that crime. You understand that, sir?
Yes, sir.
Anybody promise you anything or threaten you in any way to get you to waive your right to preliminary exam?
No.
You waive your right freely and voluntarily after having opportunity to talk to your attorney about it.
Yes.
Do you have any objection to the court signing your name to the waiver form and initialing off?
No.
Ms. Fanning, do you have any objection to the court signing your name to the waiver form and initialing off?
I do not, thank you.
All right. And the court will find that you freely and voluntarily waive your right to preliminary exam that is bound over to Wayne County Circuit Court Criminal Division for arraignment on the information, which is February 10th, 2021 at 9:00 a.m.
Thank you.
All right,
Have a
thank
great
you.
day. Thank you, Ronald. Thank you. Bye-bye.
Blair. Oh.
For what it's worth, Ron Marsh for James Young on setting for an exam.
Thanks for coming in. Oh, me, okay, thank you. McNeil? Oh, thanks.
Ready on Young, calling case number 2062591. The people of the state of Michigan versus James Young. Defendant is charged with count 1, weapons, firearms, possession by a felon. Count 2, weapons and ammunition, possession by a felon. Count 3, weapons carrying concealed. Count 4, count 5, weapons, felony, firearm, habitual offender, second notice. This matter is scheduled for probable cause conference.
Good morning, Your Honor. Dr. Brown.
And Ron Marsh, P26471 for James Young. Mr. Young, would you state your name, please?
Yes, James Garnett Rashard Young.
Thank you. All right, counsel, what's your pleasure?
Judge, although I would like to send in a gun board letter, I'm asking that this matter be set for in-person examination a bit later than sooner if possible.
Well, he's charged with felon in possession, so I doubt if he would be eligible for gun board.
I don't think you would be.
Yeah, he's not eligible for gun board. How many witnesses?
One.
Unless you got some very unusual facts to this case, I don't know.
There are some unusual facts, Judge.
Mr. Marsh, what's your P number?
P26471.
Thank you.
How many witnesses?
One minute.
One. We'll do this February 5th at 10:15.
Judge, I'm other places on, oh, I'm sorry. Friday, February the 5th at 10:15 is fine.
All right, I'll continue.
Thanks, Judge. You know, Judge, on second thought, just on this a slight chance that there might be an approval, so that I'd have more time with the gun board, could we set it a bit later?
Set for March 4th at 12:15.
March 14th at 12:15. Thank you so much, Judge.
March 4th.
March 4th.
March 4th
Yes.
at 12:15.
Thank you, Judge.
Thank you.
I'm all good.
Yep, you're good. You can sign off.
Thank you.
So, Blair, I don't have a prosecutor. The prosecutor you told me for,
What?
Fufo.
Oh, okay, that was Lori Morella Smith. I'll text her. She's not on?
I'll get right. I'll just go ahead. You have to deal with whatever data you are.
Okay. Anybody on Monique Carson?
Yeah,
Okay.
that's Earl Washington. Is
Earl?
Earl on?
He's on, I see him on.
Is he still on?
No.
And I got, Robin McCoy on Victor Moore. That's a special prosecutor too, right? Moody.
On which one?
On Moore, Victor Moore. It's the elder abuse.
What time is that?
That's 2:30 PCC.
Oh,
Yeah.
oh yeah, that's elder abuse.
Yeah, I don't have discovery on that, so there's going to be an issue with that and an issue about competency.
Oh. 439, just Josh. Yes, at 11:30. Yes, we're still doing, we're doing them. You know that, right? Council? Yeah, all in persons are going to this job. All right, thank you. All right, so Judge, you say you want me to call this one?
Yeah, I'm not, we tried to call her. It's now almost 10:30. So for 8:30, I'm not waiting long for.
Is that the Moore case or the other?
Start with the, Kupu, and then we'll
Yeah,
do more.
I just texted her. Is there anything that was on the Moore case in your file? Nobody? Let me see.
Oh, do you have a special case?
Yeah, it's an elder
Yeah.
abuse case. Did it indicate anybody?
You mean where the
Where they
prosecutor
signed it, yeah.
signs? Says Danielle Strace.
Okay, that is elder abuse. Yeah.
Yeah. it's-
Alex goes about it.
Yeah, because she's this, Katrina is like it. Yeah, cool. Ready on Katrina and Poo Poo. Calling case number 2155378, the people of the state of Michigan versus Katrina and Poo Poo. Defendant number 2 is charged with count 1, assault with intent to murder, count 2, robbery armed, count 3, conspiracy to commit robbery armed, count 4, assault with intent to do great bodily harm, less than murder or by strangulation, count 6, count 7, count 8, count 9, weapons, felony, firearm. This matter is scheduled for probable cause conference.
Good morning, Your Honor. Prosecutor.
One,
The judge, co-defendant number 1 is scheduled for January 29th, PCC.
PCC.
Yeah, the vote PCC.
Okay.
Yes,
I'm sorry? Oh, I thought I did. Blair Moody standing in for special prosecutor, Roy Morales.
And good morning, Your Honor. May I please Honorable Court, Vassal Johnson, P 72130, on behalf of Ms. Mpopo, who's present here by Zoom in the jail division.
Ma'am, state your name, please, for the record.
Katrina Amplifo.
All right, thank you.
Judge, today's daytime subject PCC. I know Your Honor's policy in terms of the setting for exam. I would just ask for a discovery in the matter. I was retained yesterday and am looking for all the video evidence such as body cams, photos, 911s, in-car, and witnesses, including Ms. Mpopo.
All right. Anything involved, discovery, in-car, any video, body cam, et cetera, your statement, basically ask for everything.
Should I repeat that for Mr. Moody?
No, we will get what we have in our possession control to you.
Well, I'm making a record in terms of.
Prosecutor, I don't think so. If you have anything special outside of the ordinary what I have, you need to send an order down to the court for a motion.
We usually discuss on the record. So
Well, I don't know what we have, Mr. Johnson, because
I want to make a record in terms of what I'm requesting, per usual.
Right, well, I don't know what you wanted, Mr. Johnson. He's not the prosecutor doing the case.
Oh, I know.
Why he said that, but he'll let her know.
Okay, that's all I'm saying.
Right, you got a record.
Thank you.
You're welcome. February 18th at 12 noon.
That works.
That's gonna be exam.
Address bond?
Yeah, hold on one second. Okay, go ahead, Mr. Lasser. Mr. Johnson, I'm sorry.
No problem. Yes, Your Honor. Ms. Sampofo here. She's 20 years old. She'll be 21 in March. She has no prior record whatsoever. Bond is currently set at 100,000 cash. She's obviously not able to post. I was retained yesterday by her mother, who's present on the YouTube channel here. She was present at her arraignment as well, and she lives with her. She has strong family support, Your Honor. She has a job lined up at Nordstrom's in Somerset, and no children. Attended Job Corps in 2018. Um, I'm asking for a, I'm asking for this. I'm asking for a 50,000 personal bond based on her not having a record, and also put her iChat. I pulled her iChat as well after being retained. There's nothing on her iChat, no prior convictions. I have it here as well. Also, because of the COVID, you see she has a mask on in the jail. She's at Division 3. In the alternative, Your Honor, I'm asking for a 10,000, 10% bond as well in the alternative.
People wish we heard.
I'm working without a file, so I don't know. All I can go is basically the charges that we have here with regards to the bond. I don't know what it is at this point.
100,000 cash.
Judge, I'm not sure if she's also a prior offender. We would indicate that we should record.
No, not showing anything prior.
Okay. Given those charges, Judge, I think that it's reasonable to set.
All right. At this point, the court, I'm not, there's no way, I'm not gonna give her a personal bond. Not with these alleged facts and charges. I will reduce the bond to 75,000, 10% with a GPS tether. And the condition that your client is not on any social media, especially Moco space.
Yes, Your Honor.
No contact with the complaining witness. And no contact means just that. You can't contact them. You can't have anybody else contact them. That's in person, telephone, text message, email, Facebook, Twitter, whatever. You can't put anything about this incident on social media. Do you understand that?
Yes, I do.
Right.
Judge, one question. If she's able to post, I'm gonna call her mother immediately. Is the date still February 18th?
I beg your pardon?
If she's able to post bond, I'm going to call her mother immediately after this hearing. Is the date still February 18th?
Yes.
Okay.
Yeah. The date's gonna stay the same because I got a code deed.
Okay. Yes, Ron. Thank you.
Thank you.
Thank you, Your Honor.
Thank you.
Oh, you ready? Did you find out, prosecutor on Moore? Is Washington on? Nope. Washington?
Yeah, I'm sending text to two APAs and elder abuse.
$75,000.
75,000.
75,000, 10%.
That Cody was up for PCC on 129, is that right?
Yep. Yeah.
I let Lori know.
Oh, yeah, we started January 19th, last week. Yeah.
Okay.
Yes, Judge.
With the ranking, right?
Yes.
We still have more in green.
No, we have more in Carson.
That's the big green.
Green is Cody on,
Oh, Green, yeah, with Rankin, Judge.
Oh.
Yeah, Rankin and
Yeah, that's done.
Huh?
Okay.
So PCCs, we just have,
More
more in person.
Carson, which I have.
You said you have a person?
Yeah,
Yes,
What are you waiting on?
Washington,
and Yale.
Earl Washington.
Oh, okay. You can't get Mr. Washington.
I can call him?
Yeah.
Great.
Did he check in?
Yeah,
Which one do you think? I have Williams.
I think that's his
Hold on,
point.
can you call
In
Mr.
jail.
Washington?
Yeah.
I'm about to call over and get it reassigned.
I think that's his point. Oh, Judge, he did call too and say he was bouncing in between courtrooms.
I'll ask if he wants me to cover for him.
Okay.
If it's something that-
County here. I actually had Mr. Earl Washington in a breakout room in Judge Cox's courtroom with also an in custody defendant at the moment. He's in a breakout room with the defendant there. I can ask him if he can sign in after that matter if you would like.
Okay, thank you.
Is that Miss Carson?
This is John.
Yes.
Is that John?
Okay, thank you.
Thank you.
That's
This
his
one
point.
thing on Moore, Elizabeth
Okay,
Dornick
can
is
you
gonna zoom in.
Okay, so that's Miss, McCoy.
Yes.
She's gonna stand in, or is that her case?
I know, they're.
How long is it gonna take?
Oh. Sounds good to me.
Okay, I'll see what I can do. Do you want me to stand it for you?
Let him know his client's on too. in jail.
Do you have discovery? Okay, I'll just stand it for you. It's fine. Yep, no problem. Go on. All right, yeah, he's stuck in Third Circuit for another 15 minutes. He says, I can cover for him if he'd be done. The client's name is Monique.
Okay. Oh, this is my
Monique
APA.
Carson.
Okay.
It's a PCC.
Elizabeth,
Hi,
hi, how are you?
I'm well. How are you?
Good. Are you on Moore?
I will, I'll stand in on more. I'm not going to be keeping the file, but I happen to be in the office today, so it is an elder abuse case. Somebody from my unit will handle it.
Okay. So it's not yours? Can I?
No, it'll probably be Aaron, Dan, or Elena Rozek, but I don't know which one.
Okay.
But I have the file with me, so I certainly can set an exam date or whatever we need to do.
Okay, can I have your P number then?
79420.
Thank you.
Of course.
You ready? Ms. McCoy, you ready on Moore?
Yes, ready, Madam Clerk.
Calling case number 1959670, the people of the state of Michigan versus Victor Moore. Defendant is charged with count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, domestic violence aggravated. Count 3, assault or assault and battery. This matter is scheduled for a probable cause conference.
And Elizabeth Zornick on behalf of the people.
Good morning, Your Honor. Robin McCoy on behalf of Mr. Victor Moore. He actually is in an adult foster home. They said that they were going to try to zoom in, but I did explain to them, I don't have discovery on this. So I would obviously be asking for an adjournment till I can get the discovery. And then another issue is that when I talked to the group the owner, they said that he has mild retardation. So if not now, I would be eventually be requesting competency and criminal responsibility in light of that.
Have you talked to him?
I tried to call over there to talk. No, I have not had an opportunity to interview him yet.
Thing about if you want to, if your intent is to make a motion on competency to stand trial, then you have to be able to say that he either does not understand the proceeding or, or that he's unable to assist you. And if you haven't talked to him, then it's kind of hard for you to say that.
Right. That's why I said eventually, because they already said that he's mild, he's in there in a group home as guardian for mild retardation. So at this point, Your Honor, we would just ask for an adjournment of the PCC so that I can have.
For exam, I can send it for exam. After you talk to him, if you feel that he needs a referral, just contact the court, and then we'll do the referral on Zoom. All right?
Okay. But I don't have discovery. Should I just put, Ms. Dornick, should I just put my email in the chat so you have the email? Because I made a request when I was first appointed. That was back on December 23rd, but I still haven't received the discovery.
Right, well, please put it in the chat and I'll make sure it gets to you.
Okay, thank you.
How many witnesses?
2, Judge.
None for the defense at this time.
All right, let's set this matter for exam February 23rd at 12 noon.
Okay, are we saying this is a live exam or Zoom or?
Exam. In person.
In person, okay. 12 o'clock.
Again, Ms. McCoy, once you talk to him, if you don't feel he's able to assist you or he doesn't understand the proceedings, just get back on Zoom. We'll contact the prosecutor, then get back on, and we'll do the referral.
Okay, all right. Yeah, I have another matter, but then I'll call over there. I'll see if I'm able to talk to him, and then I'll let you all know. So, okay, thank you. I hope everybody stays safe.
You too.
Me too.
Let's get the door now.
All right. Carson. What happened? Did you talk to Mr. Washington?
Yeah, he said I can cover for him if need be.
Okay.
We do have a exam. I don't know if you want to try to call that first to give Mr. Washington more time.
Which one?
It's Anthony Williams.
It's already 10:45?
I think we need Mr. Andrew for that.
Yeah, he was here.
Oh, he's here.
Yeah, he's here.
Okay, I don't worry about it.
Oh, well, the person.
I'm sorry, we doing Carson, Judge?
Yeah.
Calling case number 2155333, the people of the state of Michigan versus Monique Carson. Defendant is charged with count 1, assault with intent to murder, count 2, assault with intent to do grave bodily harm, domestic murder, or by strangulation, count 3, assault with a dangerous weapon, felonious assault. Habitual offender, third notice. This matter is scheduled for a probable cause conference.
Morning, Your Honor. This is Prosecutor Williams, people. And good morning, Your Honor, from Neighborhood Defender Service of Detroit, Jonathan Ortiz, P78948, standing in for the attorney of record, Earl Washington, on behalf of Ms. Carson, who appears to be zooming in from the jail. Ms. Carson, can you state your name, and is it okay that I stand in for Mr. Washington for you today?
Now turn on the sound.
Hello,
Okay, we can hear you. State your name, please.
Monique Carson.
All right.
And Ms. Carson, I'm a coworker of Earl Washington. Is it okay that I stand in for him today to cover your matter?
Yes. Yes.
All right, thank you, Ms. Carson.
All right. send this matter for further exam?
Yes, Judge, as soon as possible for an in-person.
My understanding from Mr. Hordos that Mr. Washington has in fact received the discovery that we sent back to 12521. It was digital.
Yes, Judge, I just spoke to Mr. Washington. He indicates that he has received discovery.
You ask them to have a backlog to talk to the attorney.
How many witnesses?
In this case, I have
Four?
two.
February 16th at 2 o'clock.
Understood. With respect to bond, would the court allow a bond hearing before then, if Mr. Washington files one?
Yeah.
And would the prosecution be willing to waive a 7-day notice on bond motion?
Yes, if you can email us.
I'll make sure that Mr. Washington knows.
Your Honor, Ms. Carson would like a breakout room with Mr. Washington if that's possible before going on to anything.
Oh, you basically just finished. We have another attorney from Mr. Washington's office that is standing in for him. 1 second, what's the bond? Cash surety.
Are you all set with Ms. Carson then?
1 second.
Okay.
I'm looking at. Carson, are you working?
Yes.
I beg your pardon?
Yes.
Where do you work?
I work at the bank. I put money in there every day. Michigan First Credit Union and Flag Star Bank. And I also do hair.
Who do you live with?
I stay by myself. I have my own apartment and it's brand new.
What's your address?
My address. My address.
Street name.
14th. I'm sorry. 14th.
14th.
Yes.
All right. Well, right now, her bond's 150,000 cash surety.
For personal.
I don't know if the jail's in a particular hurry, but if we do the other exam, maybe Mr. Washington will be free to make a bond argument for Ms. Carson.
Well, people wish to heard on it. That's very good. I'll find that out. That's there's no way I'm doing a personal or anything like that. I'll lower the bond. You wish to heard on the bond?
Yes, briefly, Judge, we would indicate that if the court's inclined to lower the bond, it will be a clear bond, given the fact that this apparently wasn't a case wherein an individual was struck as the defendant driving the car. He ran to that person who was lying down on the street, indicating a shake, and apparently reportedly violently, and then tried to drive away, which would indicate a condition of flight. Given that, Judge, we would indicate that the bond, once it reduces the bond, we would indicate that it's 48 high.
And Judge, I think as the court got gathered from his questions,
They're gonna have to wait.
Ms. Carson has ties to the community, has employment, has good things going for her. When assessing bond, it has to assess the danger to the community and risk of flight. Flight risk appears here to be non-existent or minimal, or could be remedied by other means. With respect to danger to the community, there's no allegations of prior violent contacts with the system that I'm hearing. Ultimately, I'd ask the court to set a cash bond that Ms. Carson is capable of posting something at $5,000 cash or less.
She got priors for breaking and entering, possession less than 25 grams, controlled substance.
That's correct. The danger to society is in fact is what happened here.
You know, the problem is, you know, you drive for your work, right?
That's correct.
Yeah, well, part of your bond already is that no, you can't drive. So how you gonna work?
I could catch the bus. I stay inside the community of Detroit, and everything is accessible. Sir.
You said you put money in ATMs, and you gonna get on the bus with that?
That's correct. Yes.
It's indicating that society would be the hit and allegedly hit and run.
All right, 25,000, 10% with GPS tether, no driving.
Thank you.
Judge, will the court make the explicit declaration that tether hours, or the tether has no hours restrictions on it? Otherwise, they default to.
I'm gonna do that. I need, no. She's gonna have to produce her work hours.
Understood.
She's gonna be able to show that she can go to work. You're not down very seriously. If she's putting money in the ATM for bank, they're gonna allow her to get on a bus to do that.
That's correct.
So, no.
Understood. And Ms. Carson, then just supply your hours to the court and the tether agent to get the permission set.
Okay, today?
Whenever you get released.
Okay, personal.
No, not personal. 25,000, 10%. So that's $2,500.
Can I ask a question?
Seeks to have that bond reviewed and wants to supply additional information.
Yeah, you can ask a question. I don't know if I can
I was
answer.
wondering if I can get it lowered, personal bond, and go straight to tether so I can get started. I have my apartment and I stay by myself, so everything is in my name. And I was asking if the courts will give me favor, I can get back to my apartment because it's locked down until while I'm in here, and there's nobody that knows I'm here. And I'm fully responsible for coming back. If I could get tether, I can tether straight to my house immediately. I also asked that being in jail, I've been in jail since the 14th, and I was wondering if I can get time served for this. My conditions of
After it's resolved. Anytime that you've been in, you get a credit for it after it's been resolved. And as for the personal bond, at this point, no. You can talk to your attorney, have Mr. Washington get in contact with you. And you can talk to him, and he can file another motion and ask for reconsideration or whatever, and tell me why. But right now, no.
Understood, Judge. Let's be sure to let Mr. Washington know. We'll see you back on the 16th.
Yeah.
Your Honor, what was the next date for Ms. Carson?
February 16th.
2 p.m., I think.
2 p.m.
I can't make it anything. I don't. Is it, it's up to the court. Is it okay if I can make it before February 16th, February 1st through the 8th?
Ma'am. That's the earliest date I can give you.
Are we all set, Your Honor?
We're all set, thank you.
Thank you.
You ready on Williams?
Ready.
Ready.
Calling case number 1557025, the people of the state of Michigan versus Anthony Lawrence Williams. Defendant is charged with MDOP utility property. Habitual offender, second notice. This matter is scheduled for an examination.
Good morning, Your Honor. Good morning to your wonderful staff. May it please the post honorable court, Reginald and here, number 80354, here on behalf of the people.
And good morning, Your Honor, from Neighborhood Defender Service of Detroit, Jonathan Portis, P78948, on behalf of Mr. Anthony Williams, who's standing behind me. Mr. Williams, can you state your name?
Anthony Williams.
Yeah, we started.
Are you ready to see?
Ready, Your Honor?
Ready.
We ask for mutual sequestration of all witnesses. I'm prepared to testify today or in the future.
No objection, we'll join.
No witnesses testifying today at trial, any future time will be in the courtroom or be denied that you testify. Officer, is that a witness or an officer?
This is the first witness.
Okay.
The officer in charge is in the waiting room, but he's also going to testify today.
Okay. All right, before you first.
Thank you, Your Honor. People call Derek Hassan to this name.
What's the last name?
Hassan, Hassan.
Yep.
You swear or affirm the truth, the whole truth, and nothing but the truth.
I do.
Right, you please go ahead. No, because probably.
Good morning, sir.
Good morning.
And can you please state your name for the record?
Derek Hassan,
And Mr. Hassan, how are you employed?
DTE Energy.
Okay, and what is your position at DTE Energy?
I'm an investigator, corporate security.
Okay. Well, Mr. Hassan, I want to turn your attention back to March 19th of 2015. Were you working on that day?
Yes,
And on that day, did you have occasion to arrive at 17130 Alcoy in the city of Detroit, County of Wayne?
yes.
And can you tell me what event occurred on that day in that location that you report today?
I was called to that property by the Detroit Police Department.
Property, is it located in Detroit, County of Wayne?
Yes. They had indicated to me that,
Okay, no. See my question.
Okay. Mr. Hassan, what event did you observe at that location?
an illegal electrical hookup.
Okay, and how did you observe this?
Through my observations there, I went to the property and did an investigation.
Okay, you did a walkthrough of the property?
Yes.
And where was the illegal hookup located?
There was a single strand piece of wire in the back bedroom that ran through the back window, down through the yard, and up to our utility pole, and it was legally attached to our secondary wires.
Okay, now how do you know it's illegally attached?
We don't install services like that. We don't have an account there.
Now you say you don't have an account there. Did you look anything up in your database or anything like that?
I did. In our customer service and billing records, we did not have an active electric account.
Objection, Your Honor, to the hearsay contained in the database.
Business record exception, Your Honor.
If they have the business records, then by all means, please, that's a best evidence objection.
Okay. He doesn't have to produce the record. You can testify.
Sorry, Judge.
He can testify as to what he reviewed in that business record. And again, this is a probable cause hearing. This is not trial. So that's evidence doesn't necessarily apply.
Judge, I understand your ruling. I disagree. I think the rules of evidence do apply fully here, even the best evidence rule. And he's testifying as to the contents of a record. I understand, obviously you read something, you want them to testify for expedience purposes, but if we're talking about the truth of what's in a record, 1001,
Again, this is a probable cause hearing. This is not trial. So, and I'm not saying that the rules of evidence don't apply, they do apply in most instances, but they are relaxed to a degree in terms of these type of hearings. So I'm gonna allow him to testify to what he thought.
Thank you, Judge. I made my record.
All right, Mr. Hassan, you looked through your business records on the database, correct?
Yes.
All right, what, if anything, did you observe?
Prior to going out to the address, I had looked at the business records. DTE Energy did not have an active agreement with that address.
One second, Your Honor. And did you take photographs of the location?
Yes, I did.
You took photographs of the illegal box in the hookup?
Yes.
And did you run any kind of test to conclude that there was actual service going through the home?
Yes, I did.
And what did you do exactly?
I put an AM tester on the line, on the foreign line that ran from the back of the house to the utility pole, but it showed that it was energized.
Okay. Now, back to the records you were observing. Were you able to tell when the electricity was hooked up again after it was shut off?
Not when it was hooked up again, no.
Okay. Were you able to come up with a dollar amount as to how much energy was being used?
Not at that time, no.
Okay. Did you do anything else while you were on location?
No.
I have no further questions this time, Your Honor.
Okay, so you indicated the police called you out to that location, correct?
Yes, sir.
And they were asking you to investigate this potential power theft, right?
Yes, sir.
Okay. And ultimately, you were cooperating with the police in that respect, correct?
Oh, yes.
And so the results of your investigation, you communicated back to somebody in the police department, correct?
Yes.
And it was your understanding that they expected you to do that, correct?
I don't know if it was my understanding that they asked me to do it.
Okay, fair enough. Now, you indicated that you did a walk through the property in order to determine the illegal hookup, correct?
Yes.
Now, you had to actually enter onto the property, correct?
Yes.
And where did you enter onto the property?
I was in the front, the back, inside,
Okay, so you walked in through the front door.
with the permission of the police department, yes.
Okay, so the police escorted you into the house.
Yes.
And then you went around the house and made observations, you
I
said.
just went to the back bedroom where they showed me this foreign piece of wire that ran out the window.
Okay, did you enter the backyard at all?
Yes.
Okay, was any homeowner present during that time?
Not that I recall.
Okay, and what date was the date that you actually physically went to the house?
I believe it was March 19th, 2015.
And how many police were present?
I don't recall.
Do you remember the names of any of the officers that were present at the time that you were there?
I remember Rebecca McKay. It's the only one that I recall.
And you earlier mentioned some business records. Ultimately, you have no personal knowledge as to what the status of that house was outside of those business records, right?
Correct.
So, this isn't some place that you've been to multiple times to take meter readings, right?
No.
You've never interacted with the owner to determine that they had a contractual agreement with DTE, right?
No.
So you're relying on the accuracy of the database that you reviewed
Yes.
to determine whether or not there was an account in status.
Well, it was later confirmed at the property.
Just asking.
Yes. Yes.
I think I'm good. Thank you, Judge.
Anything further?
Second.
All right, thank you. You step down.
Thank you.
Have a good day.
Your Honor, people call Sergeant Rebecca, I'm sorry, Lieutenant Rebecca when they take this in.
I do.
Thank you, John. Can you please state your name for the record?
Rebecca McKay.
Ms. McKay, how are you employed?
I'm employed with the Detroit Police Department.
And how long have you been employed in that capacity?
A little over 24 years.
And what's your rank?
Lieutenant.
Lieutenant McKay, I want to return your attention back to March 19th of 2015. You recall working on that day?
Yes.
And on that day, did you have the occasion to arrive at the area of 17130 Alcoy in the city of Detroit, County of Wayne?
Yes.
And what can you tell us that was occurring there that brings you reported today?
We were called by, I believe it was Sergeant Meadows at the time. They had executed a search warrant at the location and gave us a call because they discovered.
Objection, Your Honor, to what they discovered. For hearsay.
Okay, Lieutenant, you were called to the scene after a valid search warrant was being executed.
Objection, Your Honor, to the form of the question.
You were called to the scene.
You arrived on scene, Lieutenant. What, if anything, did you observe?
I observed an illegal hookup at the location.
Objection, Your Honor, personal knowledge, expertise.
Well, you get to cross-examine that with expertise. She said she observed it herself, but that's personal knowledge.
Okay.
I guess, sorry, Judge, I was more so going to the illegal link, the conclusion that it's
You
illegal hookup.
get to, I understand, I just take it as for general concept of what you're saying, not that it's necessarily illegal. At this point.
Thank you, Your Honor. So, Lieutenant, it's your observation, you observed a hookup.
Yes.
Okay. What exactly did you observe?
Jumpers in the box of the utility box.
Okay. Now, upon observing this, what did you do next?
Derek Hassan, investigator Derek Hassan from DT Energy, he was called out to the location.
And did he arrive on location?
He did.
Okay. Now, I want to ask you, at any time, was a homeowner present?
An individual that indicated that they lived at the home was present, yes.
Okay. And now, I want you to take a look around the courtroom and on Zoom as well, and let me know if you see anyone you recognize from that location on that day.
I believe the gentleman sitting in the front row there,
And can you tell me something he's wearing?
gray suit.
You want to let the record reflect that Lieutenant?
No, you believe or you, the person?
That's the person that was at the Alcoy address, that I recall, yes.
All right.
You want to let the record reflect that the witness has just identified the defendant in this manner, Sir Anthony Williams?
Record will reflect.
And Lieutenant McKay, any time during this investigation, did you have an opportunity to speak with the defendant?
Yes,
Okay. At the time you were speaking to him, was he under arrest?
he was.
Okay. And can you tell me if he was advised of his rights?
He was.
Okay, how so?
He was advised of his constitutional rights by using the City of Detroit Police Department form for the advice of rights form.
Okay, and did Mr. Williams indicate that he understood those rights?
He did.
Okay, and how did he indicate that?
I believe he initialed by each right. I would have to look at the form to tell you.
Would that refresh your recollection?
Yes.
Carlos, are you willing to stipulate that your client received, understood, voluntarily waived his rights and made some type of statement?
I can't stipulate that, Judge, but I think the people can establish it.
Well, you think people can establish it? I don't understand.
It's one thing to stipulate, it's another thing for the witness to verify. So I prefer.
I've been doing this 35 years. I understand that. I don't need the basics of law, Mr. Oil. I'm just trying to understand your, okay, go ahead, just go.
Thank you. Now, Lieutenant McKay, you indicated that he initialed or he understood his rights.
Yes, he at the very least signed the form. I would need to look at the form to be sure if he initialed by each right.
Okay. Your Honor, may I approach the witness?
Yeah.
I want you to take a look at that. Let me know when your memory's been refreshed.
Yes, so each X that I placed on each right, I advised him to read and to go over, and then to sign, sign the bottom if he understood his rights, and he did so.
Okay. And did he further waive his right to remain silent?
He agreed to speak with me, yes.
Okay. Now, do you recall the nature of the conversation?
We discussed the illegal utility hookup.
Okay, and do you recall what the defendant said?
Wait. You want to avoid there? You want to avoid there
Yes.
as to your client receiving and understanding his constitutional right?
Yes, Judge, thank you. Did you ask whether or not my client was under the influence of any intoxicating substances?
I did.
And what was the response?
No.
And ultimately, this was a drug investigation ab initio, right?
Initially, correct.
So drugs would have been something that you definitely would have been concerned about then, right?
Oh, absolutely. That's why I asked the question. It's on the constitutional rights form.
Did you have him tested at all?
No, sir, I did not.
Did you make him any promises about favorable treatment?
I did not.
Did you threaten him in any way?
I did not.
Was the interview, well, I guess I'll save that for later. Ultimately, Mr. McKay indicated to you that he had not completed high school, correct?
Mr. McKay?
Or sorry, okay, Mr. Williams indicated. Sorry. Mr. Williams indicated to you that he did not complete his high school education, correct?
I would have to see the form. I believe I did ask him his level of education. It should be on the constitutional rights. I don't have independent recollection of that.
If it would refresh your recollection to repeat the form?
Yes, please.
Okay, approach.
Yeah.
I know once your memory's been refreshed.
He stated he had completed 8 grades in school.
Okay. Did you ask him whether or not he had a good comprehension of legal terms?
Legal terms, no, but I did ask him if he could read and write. He indicated yes.
But you don't know whether or not he fully understood those rights, right?
He indicated he did understand.
I'm going to stop there, Judge. I think that's fine. I'll list an objection for grounds for the adequacy of the warning and move on.
All right, and of course, at this point, based on testimony given from time that the defendant received, understood, and voluntarily waived his right to the statement you wanted to make.
Your Honor, at this time, I'd like to have Lieutenant McKay read into the record.
Yeah.
Okay, this is a defendant's statement. I'm showing defense counsel. May I approach, Your Honor?
Yeah.
Then you can go ahead and read the statements in the question and answer form.
Do you live at 17152 Elcoy? Answer, yeah. Question, how long have you been staying here? Answer, since December 1, 2014. Question, where did you live before that? Answer, 11208 Corville. Question, who lives here with you? Answer, I live alone. Question, who hooked up the power here? Answer, Hustle Man, but the wires were already here. He just hooked it back up. I just gave him $40 to reconnect the wires. The meter and everything was all there. He went to the back for 2 minutes and told me it was good to go. Question, how do you know Hustle Man? Answer, I met him at the gas station. He approached me and asked if I needed lights, cable, asked something else. I don't remember what it was. Question, have you been truthful? Answer, yes, ma'am. Question, anything else you would like to add? Answer, no. I have had an opportunity to read the statement and it is accurate and Mr. Williams signed.
May I approach, Your Honor?
Yep.
Your Honor, we have no further questions at this time.
All right. You are not an electrical engineer, correct?
I am not.
And you do not have any particular specialty in electronics, right?
I would just say that my experience doing what I've been doing since 2008 gives me somewhat of experience in being able to identify.
Let them finish the question. You asked, let her answer.
So since 2008, I've been doing cases involving the investigation of utility fraud and MDOP public utility. And in that time, I have been able to identify when it appears that power is being illegally used.
Do you possess any special certifications in that regard?
No.
Do you have any special training in that regard?
I would say my experience would be training since 2008.
My question was, do you have any training in that regard?
Well, yes, we did receive training from DTE Energy, actually.
And how long ago was that?
That was probably around when we started conducting these investigations, which would have been 2008, maybe early 2009.
Did you get a certification from that, completing that course?
No certification.
Irrelevant.
It goes to whether or not she can make the assessment, Judge. It's
No. It doesn't go to whether, I determine whether or not she can make the assessment.
Fair enough, Judge. I'll move on. Now, this was, you said this was 2015, right?
It was.
So the last time that you saw Mr. Williams was almost 6 years ago then, right?
Yes.
And you said that you first said that you believed it was him, but then you said you were sure.
No, it's him.
Okay. With a mask on 6 years later.
Yes, that's correct.
Was he wearing a suit at the time?
I'm sorry?
Was he wearing a suit at the time?
No, he was not.
Now, I asked you a question on board here about the affidavit. The search warrant, did you have any part in obtaining the search warrant?
Did not.
But you did have a part in executing the search warrant, correct?
I did not.
You came to the location after the search warrant was already executed?
That's correct.
Are you familiar with the contents of the search warrant?
I did not review the search warrant before taking the stand. I believe it's narcotic related.
Yes. Do you recall, was there any indication in the search warrant as to?
Since you didn't review it.
I'll stop my questioning there. Thank you.
Nothing further, Your Honor.
Thank you. Just step down.
Thank you.
Anything further?
Nothing for the people, Your Honor.
No witnesses for the defense.
Your Honor, this time people move for bind over charge of complaint and warrant on the sole count of MDOP utility property. We heard from Investigator Hassan that he did make a location of 17130 out 46 Detroit County Wayne to be observed. An electrical hookup that was illegal. He did indicate that he looked up the business record, that there was no electricity or power that should have been to that location. We further heard from Lieutenant McKay that the defendant did admit that the hookup was illegal. Understanding that MDOP utility property, people must prove that the defendant's lawful authority willfully cut, broke, obstructed, injured, destroyed, or tampered, or manipulated electrical line. With that said, the people's position is that because Mr. Williams paid for the electrical hookup, he was present when it was hooked up, he was complicit in the hookup. This is an illegal hookup as well. So we're asking to bind over as charged with any warrant.
Judge, I would object to the bind over. First, dealing with the elements, as Mr. Andrew finished. I think in order to prove this charge, they have to prove that my client damaged, cut, tampered with, etc., this utility line. His statement indicated that he paid someone to just basically plug in some wires that were already there. He said that his statement did not indicate that the tampering with the line or anything like that was something that he caused, but something that was a pre-existing condition. People are really making a case out for is a kind of theft, but not malicious destruction of utility property. It doesn't meet the elements here with respect to my client's actions, either by virtue of his direct action or as an aider and abetter, if he's saying that the line's already there and we're taking his statement to be true, which I think you have to do for the purposes of analyzing these facts, because there's no facts that contradict that on the record. With respect to other issues, though, Judge, I would move to suppress the statement by virtue of an unlawful arrest and search in this case. The arrest only comes by way of a search on this property. The affidavit and the search warrant were not introduced into evidence. However, multiple witnesses indicated that this was a drug-related search. I can, for the purposes of making this evidentiary ruling, I can submit into evidence or submit for the court's review the affidavit and search warrant, but in nowhere did it reference the collection of information regarding utilities or inspection of utility lines. Therefore, I think the proceeding.
Why would it happen?
Judge, I think otherwise the search warrant is too broad. It's not specific to this particular offense.
So you're telling me if you have a search warrant for drugs and you go search the premises for drugs and you find a dead body in the premises, the dead body is irrelevant because it's not in the search warrant. That's what you're telling me. That's your argument now.
Judge,
So
I would argue that this is not the same kind of plain view exception that would normally apply.
it was all in plain view.
Fair enough, Judge. I think I've made the record on that particular objection.
All right.
With respect to, again, with the suppression argument, I would argue that because the people did not produce any officer that was involved in the raid team, they did not produce anything related to the search warrant evidence, that there's no legal proof that this was a legal search and seizure, and therefore the arrest would be invalid. Subsequently, because of an invalid arrest, that the statement should be suppressed.
I want to make sure I understand your argument. You're saying that they have to prove it was a legal search and seizure, not that you have to disprove that.
I think the burden's on the people, Judge.
Burden is to put it out there. Once it's out there, it's your obligation to prove that it was illegal.
Understood, Judge. Then again, I would just reiterate that first point with respect to the elements. Again, not meeting the elements of tampering with or harming the utility. Again, I think that's really the crux of this. That even assuming everything comes into evidence, assuming all of that, that people have not proved malicious destruction of utility property by virtue of plugging in pre-existing wires.
Understand. Anything further? Any rebuttal? Brief.
Briefly, Your Honor, the testimony was that Mr. Heston observed wires that were strewn from the back bedroom outside the window. And the testimony from Lieutenant McKay that the defendant acknowledged that there were wires already there. So it's a question of fact as to how the wires were there to produce electrical hookup before Hustle Man even arrived to do the hookup. I would say it was a question of fact for a jury, Your Honor.
All right. Court, having heard the testimony and arguments, finds that as follows. First from DPE investigator, Mr. Garrett, that on 3/19/2015, he was called to the area 17130 Alcove in the city of Detroit to investigate what was assumed to be an illegal electrical hookup. Getting there, he saw an illegal wire running through the back window to the pole wire, and it was attached there. There was no service at the address. The amp tester was put on the line and was energized. We also heard from Lieutenant Rebecca McKay testify that she went to the address of 17130 Alcoy, and this was after a search warrant had been executed. That she talked with the defendant, who was under arrest at the time, and that she gave him his constitutional rights, that he initially assigned the constitutional rights, that he could read and write, so that he was not under the influence of any type of drug. That the court found that he received, understood, and waived his constitutional rights in a statement. Part of that statement was that he met a person who he called Hustle Man and gave him $40 to hook up the electricity. That when Hustle Man got there, the wire was there, running from the line, and that he just completed the hookup so that electricity could run. That is more than enough. He doesn't have to be the person, that Hustle Man does not have to be the person that put the wire there. he then manipulated what was there, which made him complicit in the first part of attaching that wire, which was damaging property belonging to the E, right, and stealing electricity. So, and being that Mr. Williams, in this case, according to the testimony, paid him to do so, he's complicit in it as an aider and abettor. Well, actually, he's one of the aider and abettors. He's the person that initiated it. So the court finds that the felony enumerating the complaint warrant did affect the current city of Detroit. Probable cause of this charge and will be bound over Wayne County Court Criminal Division, arraignment on the information, which will be February 10th, 2021, 9 o'clock a.m.
Thank you, Judge.
Thank you.
Your Honor.
Hey, 1 minute, too.
We have the attorney for our 1130, but not the defendant.
No. I have your number.
We also have police officers.
Oh, yes, thank you.
Okay.
Take care.
But not the defendant.
Have your one.
You go.
Yeah, excuse me.
Mr. Washington?
Yeah, did Mr. Hardos handle Monique Carson?
Yes, he did.
Oh, okay, great. What date did we get on that?
What was that? Miss Carson, right?
Yes,
February 16th at 2 p.m.
Okay, great. All right, thank you.
All right, you're welcome.
All right, everybody have a nice day.
You too.
Excuse me.
Yes.
I'm coming from Christina McFell's office, and we were supposed to send our appearance to her, the clerk. But she spelled your email. Can you give me your email so I can send you our appearance?
It's ORQUID as in David, IA .ORIEL at 36districtcourt.org.
I know, we gotta get Judge out here.
Okay, thank you.
You're welcome.
Is it? Walterian? Walterian.
William.
William. Yeah, that's.
That yours?
No, that's not.
12 o'clock is yours, all right?
The noon is, yes. Yeah. Yeah.
Ms. Bashers?
Ready? Okay.
Bashers? Mr. Moody?
Who?
Bass. Ain't the one, that's the one next.
Yes? Oh, yeah.
Oh, that's his first name. Okay, they got
Yeah,
it.
that's Walter.
Yeah, they got it backwards. Huh?
Is that Court Officer Kim Williams? Is that Williams? Hiding behind that mask. What do you do?
How you doing?
Awesome stuff.
Huh?
Awesome.
What's grandson you doing?
Nothing.
Yeah,
Those grandkids are fine.
they're fine, good. They get the candy bars I sent them for Christmas.
That's our son, the grandkids are allowed to eat candy. My son can't. Yes, her son they can't.
Now make sure I send it to him.
Calling case number 2059784, the people of the state of Michigan versus Bass Walter Terrian. Defendant is charged with count 1, malicious destruction of fire or police property. Count 2, police officer assaulting, resisting, obstructing. This matter is scheduled for examination.
Good morning, Your Honor. Prosecutor Blair. For the people, we are prepared to proceed. We have our officers here.
And good morning, Your Honor. Quentin Docs, P number 79657. On behalf of my client, Mr. Basil Terry, Your Honor. I have not spoken to my client since the PCC. I have sent a letter stating the date and so forth.
Okay. So now that's for examination and it's also here, keep yourself there. Any bond previously submitted shall be forfeited. Any bond set, 30,000 finished.
Thank you, Your Honor.
Thank you.
Thank you. Next one's 12 o'clock, yellow.
Hey, Judge, this morning, I didn't get a chance to chime in. You sent an exam date for February 8th, at 10 a.m. with Miss Demont Brady. I'm going to be in, 34th at 10 a.m. So I'm actually trying to work things out. I have a 10 a.m. with King and a 10 a.m. at 34th for live exams. I'm trying to work those two out, and then this third came, and I realized that after we went off the record, and I didn't want to interrupt the next case. So I mean, I can still try and work things out and let you know. And I'm trying to waive the one at 34th, which means I'll be here at 10. I know Judge King will wait until we're done here. I don't know if you want to.
What day is it? What day is it?
It is a Monday.
No, what day did we set it for? February what?
February 8th.
Oh, 8th, okay.
I mean, I can still try. I mean, we got a little bit of time to try and work things out. I'm still talking to defense to try and waive the 34th exam. So can I just let you guys know?
Yeah.
Yeah, absolutely. No, we'll do. I'm trying to talk to the defense probably either today or tomorrow. Get this worked out. All right. Thank you much. I will see you all tomorrow. Everyone be safe. Be well.
You too.
Thank you.
Oh.
You can get that guarantee right now when you check that out.
Sir, can we help you? Gentleman on the iPhone?
Good morning. This is Alexandria Poole from DS. I'm here, my client, I believe, is on Deontay Folks. We have an exam that's set for 3 o'clock today. And it's one where we were hoping to have a response from the gun board letter, from the gun board committee that we have not received. So we decided to Zoom in instead.
Decided to what?
Zoom in instead. Are you having a hard time hearing me?
No, you just faded out at the end. I couldn't hear you. The exam's at 3 o'clock.
Yes.
Okay. So what do you want to do?
If Your Honor is not willing to give another adjournment, which I would understand, we could waive at this time.
All right. You call it in.
Yes, Judge.
You have any objection to the waiver of the folks' case at 3 o'clock? Oh, okay.
No, Judge. It's a CC.
Instead of waiver?
Okay. Just want to know. I just want to know.
Calling case number 2057237, the people of the state of Michigan versus Dante Folks. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
Good morning, Your Honor. Prosecutor Washington for the people.
And good morning, Neighborhood Defender Service of Detroit by Alexandria Poole for Mr. Deontay Folks, P83670. Mr. Folks, can you state your name for the record?
Deontay, folks.
Your client wishes to waive his exam.
Yes.
Can you hear me?
Barely, hold on. All right, Mr. Folks, you understand that you have a statutory right to a preliminary exam where the state must show by probable cause a crime was committed and probable cause you had something to do with committing that crime. Do you understand that, sir?
Yes.
Anybody promise you anything or threaten you in any way that you waive your right to preliminary exam? Mr. Folks?
No. No.
Okay.
Can you?
Yeah, we can hear you. Okay, and you had opportunity to talk to your attorney about this, correct?
Yes.
All right, and do you have any objection to me signing your name to the waiver form and initialing off?
Mr. Folks?
Mr. Folks?
No.
All right, thank you. And Ms. Poole, do you have any objection to signing your name to the waiver form and
No, Your
initialing
Honor.
off?
No, Your Honor.
All right, you want to find that you freely and voluntarily waive your right to preliminary exam that is found over Wayne County Circuit Court Criminal Division.
No. You can't hear me? I said no.
Okay, I got you.
Yes, we heard you.
Yeah, we got you. All right. Court will find that you freely and voluntarily waive your right to preliminary exam. That is bound over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be February 10th, 21 at 9:00 a.m.
Thank you.
And Bob, continue.
Mr.
All right,
Folks,
thank you.
you can sign off. Thank you.
Good to see you, Ms. Poole. Yes.
I can't believe that the 12 o'clock attorney is coming to do this case.
Why you say that?
It's a waste of firepower.
Oh.
They'll send somebody else. Or call in on something like. Have the police officers.
Read. You need to die in the hallway because we have all too much cologne. Oh my goodness. And I had to think of that office for that week.
Even with your mask on?
Yeah, I got 2 masks on.
I know, right?
Got that one, and
Nope. As you know, they probably want to see if the witnesses show up. Is Mr. Wesson here?
Mr. Wesson.
12 o'clock.
Not here. No. Just a police officer.
He said she's at home. Mr. Allen. There you go. He's- Williams. I said, what are you doing? You were supposed to be doing that. That's not how you're supposed to do it. Yes, I have to work on it. You want to send somebody else to get it? You're welcome. You don't have no sense. Oh, yeah. You want to?
Which one is
Come
it?
and in, just make sure it's right.
Oh. You know, I haven't really done this in a long time, but
Okay,
it's
good.
right. It's right.
You don't know what that is.
It's like riding a bike. Only, let me see something.
Is he coming back in?
He is, let me see. That's
Well, that is good, yeah.
Right. And he is, but, his next court date. Yep, you got the next court date.
Right.
But you got to do the order, right?
Together.
Yeah, you got to do the It's like 2 weeks out, but I still do it.
Okay.
Because it's so close. That's it.
There needs everything that's pocket. Kitty, next week, are you gonna actually ski or you gonna sit live? You can
I'm
sit
gonna
live
ski.
and sit by the, not talking by the fireplace anymore, I don't think.
Right, it's been too many times. No, I'm gonna ski. Hopefully, if everything works out, I can get it together this time.
I gotta take my ski, when I looked at mine the other day, it was so dirty, dusty.
When's that last time you
Wax.
was
Can you hear
skiing?
me?
Oh.
Hello, how you doing?
Hey, Miss Diallo.
Hi, everybody. I don't see my client there.
He's not here yet. He hasn't checked in yet.
Okay, well, I'll just wait here. He got 3 more minutes, so I'm going to wait right here.
Okay.
I'm going to get my first shot tomorrow, everybody.
Oh, yeah.
All right.
Yeah, well, they just had an outbreak. They just had an outbreak in Lincoln Park, so. Allen Park.
I'm supposed to go get mine Friday if I don't chicken out.
Don't chicken out. Don't chicken out.
I ain't worried about it hurting.
No.
I'm worried about what else is in there.
No, the one we're getting is Moderna. That's the good one.
Oh, I got Pfizer.
It's okay.
The Moderna is better?
To me, I think it's more in line with our physiology.
Oh, great.
I don't know. At first I was gonna wait for Johnson & Johnson because their shot is just one shot.
Yeah.
I don't think we can wait. This new strand right here is jumping. It's real contagious.
So. Yeah.
He's not out there more?
No, he's not.
Miss Diallo, you must know he ain't gonna show up.
Huh?
You must know he's not gonna show up.
Well, I'm hopeful. I'm always hopeful.
Cover my ears.
Oh.
I guess it's 11:59, so.
Hey, Gavin, that's a real. I'm in the.
We'll be ready on Weston?
Ready.
So, you have a ride down here?
I was seeing if Blair had his witnesses.
Does?
Yep.
That's what he says.
See for yourself.
That's funny.
It was Jalen Weston, but I'm just gonna let them know that there's no line.
How's everybody been at home for you, Miss Diallo? Good?
I'm sorry?
Everybody been good at home?
There's no.
We're working on it.
Nobody
Okay.
line outside.
Glad to hear it.
It's because you've been lying to us.
Oh.
It's no line, he's not outside.
Maybe he's just pulling up.
Okay.
Maybe he's on his way up.
Well, I called downstairs and the sergeant said there's no line out front.
Oh my.
Nobody-
Okay, it's 12:01. I guess we can call it.
Calling case number 2059527, the people of the state of Michigan versus Jalen Wesson. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination. Defendant has failed to appear.
Good afternoon, Your Honor. Since the prosecutor Beverly for the people, we do have our police officer witnesses present. We are prepared.
Thank you. Good afternoon to you and your staff, Lillian Diallo, P52036, on behalf of Mr. Wesson, who unfortunately is not present.
All right, well, get yourself in there. Any bond previously committed shall be forfeited, new bond said 30,000 cash.
Thank you. Everybody stay safe. Take care.
Take care.
Bye.
You too.
Thank you. Judge, I think she knows her routine though.
Yeah.
Yeah.
She knows. I let Mr. Dox know that too, to see the guy, bring him in. Rather than go through the whole shebang.
Right.
Did you tell, you told Quentin Dox that?
Yes, I did. I said, if you get a hold of your guy, walk him in before he gets picked up.
That's it, till 1:30.
1:30, Judge?
Okay, what do we got at 1:30?
Child abuse.
Okay, that is child and family abuse unit. It should be, my records indicate, Jennifer Teague.
Okay, and
And
then
then,
15, we got, Stephen Fulton and motor vehicle.
yeah, that should be Reginald.
Oh,
Oh, so you're done?
I think I'm around.
Oh, because you're
Yeah,
3
we know
o'clock
that.
late?
3 o'clock late, yeah.